Hello, good afternoon or good morning as the case may be. My name is Ellen McCarthy. I am the Senior Product Underwriter and Risk Manager for the Lawyers Professional Liability Program at Swiss Re Corporate Solutions. I'm very pleased to be here today to facilitate this webinar titled Beyond Litigation, the Other Duties of a Trial Lawyer. As an attorney and a former legal malpractice claims handler, I've seen firsthand some of the claims that arise against attorneys during the settlement and negotiation process, and I'm looking forward to learning more about what can be done to prevent these types of claims. Before we get started, just a couple housekeeping matters. First, continuing legal education credit is not offered for this program. However, if you need credit and would like to submit it, we will be happy to supply you with course materials and a record of attendance so that you can self-report your credit. Just email me, please, at ellen_McCarthy@swissre.com, and I will get you those materials. Second, the audience will be muted during today's presentation. However, if you have any technical issues or any questions for the presenters, please use the Q&A functionality on the toolbar, and we'll try to reserve some time at the end to respond to your questions. And now I'm very pleased to introduce Jeremy Babiner and Jack Milligan. Sorry, Jack. Jack is a settlement planner, financial advisor, and government benefit specialist. He's advised plaintiffs and their attorneys for over 30 years and regularly speaks on these issues. He triages cases for plaintiffs and trial lawyers, advises on lien resolution, financial options, and a variety of settlement strategies. Jeremy Babiner is a tax lawyer specializing in settlement issues. He is the chair of the Society of Settlement Planners Legal Committee and a former fellow in the U.S. Treasury's Office of Tax Policy. He's currently special tax counsel at Lane Powell. One final word before we start. For those of you online who are insured with Swiss Re Corporate Solutions, first, thank you very much for your partnership. Please know that we have partnered with our speakers to offer 2 new benefits as part of your legal malpractice plans that I'm very excited about. They're offering a settlement triage service as well as a discount on a set of template engagement documents that will help protect you and your clients in your engagements. For eligible firms that buy and use these documents, we, Swiss Re Corporate Solutions, may offer a reduction on your malpractice insurance premiums. And you can read more about that on this webpage, and the speakers will talk a little bit more about it at the end of the presentation. And now I'm going to hand it over to Jack and Jeremy. Thank you.
Thank you, Ellen. Hi, everyone. I'm Jeremy Babiner. As Ellen said, I practice tax law with a focus on litigation issues. Today we're going to talk about the ethical issues and the ethical duties of plaintiff lawyers kind of beyond your traditional trial and representation duties, and we'll talk quite a bit about what the American Bar Association has to say about that. We're going to discuss problems raised by these duties, and then we'll talk about the solutions, some of which Ellen was already mentioning. Like many issues in legal ethics, the solution's often to give your client certain information, disclosure, and document that you did so. And it's all very doable. You can prepare that documentation with the help of specialists when we're talking about tax and finance and government benefits issues on your own. You can do it, kind of by learning and working the issues. Most of them do relate to that kind of the tax, finance, government benefits. We have created a set of template documents that you can use, kind of the shortcut, if you don't want to kind of build that on your own. And we'll talk about that a little bit more in the presentation. So today we will see if I can move these slides along. Today we'll walk through, starting out with, we'll talk about plaintiff clients' evolving needs. And as a result of those evolving needs, there's an evolving list of lawyers' duties, which the ABA and ABA commentary has discussed and expanded over the last couple decades. We'll walk through some of the data on malpractice claims, and then we'll talk about some of the ABA, kind of the most relevant ABA model rules that clients might point to if they were going to complain that their lawyer that their personal injury lawyer committed malpractice relating to subjects beyond litigation. After that, we'll talk a little bit about how you can safeguard your practice, and you can do that yourself or getting help from others, all very doable. As Ellen said, please write in if you do have questions in the Q&A, and we'll try and monitor that and also hit those at the end. Why don't we start off with Jack, if you want to kind of jump into plaintiffs' evolving needs.
Great, thanks, Jeremy. In personal injury cases, the value of a plaintiff's recovery can be measured by a number of considerations beyond the cash plaintiffs receive. Taxes are always relevant. So what portion of the settlement is taxable? Can fees and future medicals be deducted? The answers change as courts reconsider old rules, and sometimes with legislation like the 2017 limiting of deductions for legal fees, sexual harassment expenses, and financial advisory compensation. So financial options should also be considered, especially if a significant recovery is possible. For instance, a special needs trust may be required to avoid the loss of government benefits once the claimant receives a large sum in a settlement. And also, a structured settlement may help a client avoid spending the recovery too quickly. It's also considered a responsible set-it-and-forget-it option, which may work best for highly impacted and less sophisticated clients. But allowing a client to get overstructured by a pushy defendant can also be a problem. Lastly, Medicare's behavior can have a huge impact on the value of a plaintiff's recovery. At settlement, Medicare and its for-profit partners, the Medicare Advantage organizations, will demand a portion of the settlement as reimbursement for past conditionally paid medical expenses related to the injuries and conditions that are being released in the litigation. And then going forward, Medicare can deny payment for these same related medical expenses if they can show that the plaintiff received money to cover those expenses, or if they've discovered that the plaintiff has had a settlement or received funds, including funds for presumably future medical. So with each of these subjects, you run into different fact patterns and rules. Especially in smaller cases, it won't make sense for plaintiffs to hire specialists, but many of these issues will still be relevant. And if the clients aren't told, they may well assume that you're watching out for those problems, which takes us to your evolving duties. Now, Jeremy will get to the actual rules in a bit, but a couple of lines from ABA commentaries sum it up really pretty well. A trial lawyer must, number one, ensure his client is informed about the options of structured settlements, trusts, and the effect of the judgment or settlement on the client's public benefits eligibility. And two, a trial lawyer must make sure the client's interests are best served, for example, by considering the tax implications of any settlement. So, in short, if the client has evolving needs, you have evolving duties. And since courts and legislation change clients' evolving needs, in a very real way, your duties are always changing. As lawyers, you're used to changes and updates. The problem is when nuance and updates are outside your focus. Watching for them, not always practical, which is why you sometimes bring in specialists and co-counsel. Or, as we'll note at the end, identify prepackaged materials that you can use. But at the end of the day, this is about protecting yourself, and many plaintiff lawyers already take the step in their engagement letter to narrow the scope of representation. And that's a very good first step. Just know that the process and subject matter make a difference. ABA rules state that a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. Reasonable in this context is an evolving standard with some courts looking to the regularity with which lawyers exclude an issue from their scope. So one court has held that a plaintiff attorney couldn't exclude basic lien services at settlement, and another that a workers' compensation lawyer couldn't avoid responsibility to identify personal injury claims, at least not entirely. So, getting informed consent means that the client has to understand what they won't be getting from your work. The DC Bar wrote, and I quote, "Because the tasks excluded from a limited services agreement will typically fall to the client to perform or not get done at all, it is essential that clients clearly understand the division of responsibilities under a limited representation agreement." So with online advising happening more and more, especially during COVID, scope limitations have become increasingly common. I think we've all seen it. State bars are responding by adopting rules on so-called unbundled services, which could affect plaintiff lawyers' ability to limit the scope of their representations. In any case, as Jeremy will touch on later, it's important to inform your clients of the limitations, the impact of those limitations, and then document that you did it. You do so to inform your clients, but also to minimize your own liability. This serves them, and it definitely protects you. Now, the ABA has maintained their annual profile of legal malpractice claims for decades. Their statistics show that plaintiff lawyers are the most likely lawyers to become defendants. Former plaintiffs have sued lawyers, and law firms have paid out in many situations. Here are a few examples. When lawyers incorrectly assume portions of a settlement are tax-free. When the settlement agreement fails to allocate to non-taxable damages. When a recovery results in loss of government benefits. When a recovery would have earned better returns if paid out over time. And when a recovery would have earned better returns if paid out over time in a tax-exempt instead of a taxable annuity. Big case there happened in the early 1990s. And then when portions of a settlement are later found to have reimbursed for past covered Medicare expenses, firms have been forced to reimburse out of their own pockets and even to pay double damages for not complying with Medicare's secondary payer statute. And that's out of pocket since double damages are essentially punitive damages and not covered by malpractice insurance. And the most famous case in this regard, probably the first one in the country, the case of Paris Blank Law Firm in Richmond, Virginia. So again, addressing these issues ahead of time is all very doable. And before Jeremy jumps into the actual ABA rules, I'll note just a few statistics on trial lawyer malpractice liability. First of all, you're likely to face at least one malpractice claim. On average, according to the ABA, on average, a trial lawyer will be sued for malpractice 3 times over a 30-year career. And claims won't necessarily come in your first years of practice. 65% of malpractice claims are brought against lawyers more than a decade in to their career. And this is all about plaintiff lawyers. Plaintiff lawyers represent more than 20% of the malpractice claims against lawyers. After that comes lawyers in real estate and family law. Actually, probably family law is first and real estate second. In fact, when you're negotiating a case with a defense lawyer across the table, you are literally 7 times, 700% more likely to be sued by your client than they are by theirs. Third, this isn't about firm size. Firms with under 5 attorneys represent 70% of malpractice claims. Rest go against the larger firms. The ABA has a number of theories on why trial lawyers get hit so much more, including that you take on more cases. The cases you take on are often more complicated. And it's also that the typical plaintiff case is a much more valuable case, higher value. In any case, plaintiff lawyers have good reason to set up safeguards, in your processes. And safeguarding starts with knowing and addressing your ethical obligations. And safeguarding is completed by addressing your ethical obligations, by clearly communicating to your clients what you will and will not do for them, and giving them enough information and time to address anything outside of your scope. So now, Jeremy, I'm going to turn it back to you to walk through the relevant model rules of the ABA, many of which I think have been adopted around the country.
Yeah, that's right. There are 5 rules we'll kind of hit on today that are particularly relevant to plaintiff lawyers. We'll start with the most important of all rules, 1.1, which is the requirement of competence. So 1.1 says that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. I'm sorry, 1 second. We just had a bit of a jump in our slides. Let me just push us back to the right one. So for plaintiff lawyers, well, actually, let me first share the commentary. So the ABA commentary actually interprets this. It says, perhaps the most fundamental legal skill for a lawyer consists of determining what kind of legal problems a situation may involve, a skill that necessarily transcends any particular specialized knowledge. So for plaintiff lawyers focused on negotiation and litigation, this means knowing enough about the ancillary issues, the ancillary subjects, to identify a plaintiff's potential legal problems, and enough to advise the client whether the concern is important enough to warrant outside help and fees. So this is where, today we're really focused on the issues outside of the traditional trial lawyer duties. So, the kind of the biggest ones are tax, finance, and Medicare. So this is about observing when the client is going to have or may be exposed to risk on those other areas. This is where kind of competence is all about identifying when they might need that advice, so that you can tell them, so that they can either choose to go get that advice or choose not to get that advice. But the trial lawyer, and this is what the ABA commentary has said time and again, the trial lawyer is expected to be the hub, the person who spots those issues. Okay, so now beyond competence, plaintiff lawyers must, of course, exercise diligence. Actually, I'll quick note, after each of these rules, I'm going to just provide a slide real quick to note the states, the jurisdictions where the ABA rule has been modified in its adoption in part. In almost all of these rules, the modifications are slight. They do not affect the overall gist of what we're talking about today, but I am noting them in case you would like to go and review your own state's rules. But so beyond competence, plaintiff lawyers must exercise diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. An ABA commentary states that a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. A lawyer should carry through to conclusion all matters undertaken for a client. It's that last line that is particularly inconvenient for personal injury lawyers, this concept of carrying through to conclusion all matters undertaken, because of course the personal injury claim relates to multiple other matters. This can mean sticking with the client post-recovery until certain open loops are closed. Lien resolution, government benefits are good examples. Of course, if you've already handled them before or as a part of the recovery, you're able to close that loop at the time of recovery. And actually, as Jack was talking about, handling them before the recovery can change the scene. It actually can increase the net recovery. And so a lot of the time when we're working with personal injury lawyers and with plaintiffs, a lot of the kind of issues that can come up or can still be open after the recovery we always will recommend that they are dealt with before the recovery, because often by dealing with them before the recovery, not only are you addressing it in advance, but you are also increasing the net value of the recovery itself. Again, here are the states that have a little bit of a different version of the rule. Texas actually does not have that particular rule. Next up is 1.7, conflict. So lawyers must, and this we're all pretty familiar with this, lawyers must avoid any significant risk that a representation of one or more clients will be materially limited by a personal interest of the lawyer. For a plaintiff lawyer, this can get tricky if a client insists on an aggressive Medicare or tax strategy. Of course, there are other areas as well, but for example, with Medicare, the lawyer, the personal injury lawyer, can be jointly and doubly liable to pay a set portion of the recovery to Medicare. And if that's not done, Medicare and can sue the lawyer. And of course, using privilege, the lawyer's ability to defend that the lawyer's actions may entirely rely on using privileged client information. That may be the only viable defense. And so this is where getting ahead at the time of engagement is invaluable, because you can inform the client of that, get their written consent that you are able to use that information for limited purposes. The ABA commentary states that to determine whether a conflict of interest exists, a lawyer should adopt reasonable procedures, and this is one of those kind of basic reasonable procedures, getting it as part of your engagement process and getting that written informed consent. Again, a quick look at the jurisdictions that have a modified version of that they've tweaked to some extent, but it has not changed the overall purpose or duties. Some do require more substantive disclosures to the client, laying out the consequences of waiving a conflict. I noted that Medicare has sued lawyers long after closing the case. Now, knowing that happens, that the lawyer could actually face an issue long after closing the case, it's important to think about rules relating to former clients. They're not really that different than the rules relating to current clients, but there are some nuances. 1.9c says that a lawyer who has formally represented a client shall not thereafter use information relating to the representation to the disadvantage of the former client or reveal information. So, as I said, if a plaintiff lawyer can be held jointly and doubly liable, if that happens, the ethical rules can tie your hands unless you require that the clients allow you to defend yourself. And you can do so if you get that permission in advance. Again, many states tweak the rules, but they're not changing the main thrust. The last rule I'll go over takes the competence rule one step further. In addition to identifying the potential legal problems that the clients may face, lawyers also have a duty of referral. 2.1 states that a lawyer may refer to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Now that doesn't require much, right? It's really just an option. However, the ABA commentary says what to do when we as lawyers cannot give advice on the subject because we don't have that knowledge. Where consultation with a professional in another field is itself something a competent lawyer would recommend, the lawyer should make such a recommendation. And this is where one of those areas where plaintiff lawyers are being required to do quite a bit more, and that is based on plaintiff's evolving needs. For plaintiff lawyers, this means that after you identify a problem you can't address, it's important that you recommend that your client work with a specialist, someone who is able to give that advice, and the importance of doing so, what they risk by not doing so. In many circumstances, it's probably necessary to help identify specialists who can advise on tax, finance, government benefit issues. Some ethics rulings have also talked about the manner in which a lawyer makes the referral. They've held that referrals must be, quote, based on assessment of the quality of the third party's services and the fairness of the price. And on top of that, the lawyer must provide enough information for that referral for the client to make an informed decision. We'll talk about how to recommend specialists in a minute. But again, this is where we have kind of evolving needs of a client, and that converts into evolving duties for that lawyer. Jack, I'm going to turn it back to you to talk a little bit about safeguarding your the law firm's practice.
Okay, sure. So, when said the right way, there's nothing wrong with telling a client what you won't do. For example, how often does a doctor say, "That's not my specialty. I'd be glad to refer you to a specialist"? In the same way, it should feel appropriate to say to clients, "I'm no tax lawyer, so tax advice can't be part of our engagement. If a settlement comes and it might be worth hiring a tax lawyer, we'll discuss it and you'll decide what to do." So from an ethics perspective, the important thing is to identify work that you won't do, and when appropriate, make sure the client has enough notice and time and information to consult qualified specialists. Then document that you did so. And as I mentioned, and I think Jeremy mentioned, you can prepare that documentation with the help of certain specialists or on your own by learning and working with the issues. Most of the relevant issues, the big ones, relate to taxes, financial options, and government benefits. We've created a set of documents, and whether you acquire ours or build your own, they should accomplish 3 functions. First, they should narrow your scope of representation to the work you're prepared to do, and none of these other items. Second, identify and explain the non-litigation impact of the client's case and choices, including tax issues and liability, financial options, government benefits. Consequences are sometimes surprising and we know are nuanced, so be sure an expert confirms that you've covered all the important issues and points. And third, refer the client to specialists, demonstrating your diligence by noting their qualifications and competence. You should have some familiarity with obviously with the specialist, so you can talk about these qualifications, their qualifications and competence. So when a client follows a specialist's advice, it's important that your responsibility be limited to your recommendation of a competent professional, and then that's where the line is drawn. And of course, you want to get all 3 of these in writing. Jeremy, I'll turn it back to you for comments on those.
Yeah, absolutely. And in fact, I brought up on the screen the reference to the Society of Settlement Planners. So there are multiple organizations out there, but the Society of Settlement Planners is probably, if you're not already working with with advisors, this is a great place to go, because they are effectively focused on providing holistic planning. So, for example, there are all kinds of different issues that can come up in any one case, and often there will be several issues in a single case. But you want to make sure before you're recommending and referring someone, a client, to an advisor, that they're going to be able to handle these kinds of issues. And here are just some examples. So there's, many clients will need a life plan funding analysis. Is this something they offer and can do competently? Are they going to need to provide lien resolution services? Are they experienced and connected with a number of trust companies so that the client will have choices? Can they address the different Medicare issues? Structured settlements, while very common, and often very, very powerful and useful, are often incredibly prone to overuse. And it's not overuse as much that they shouldn't be used in the case as much as they shouldn't be used to as much of an extent. You might be choosing between placing 20% versus 40% of proceeds in a particular investment. The use of qualified settlement funds. There's also, as a personal injury lawyer, hopefully you're able to lean on them for mediation and negotiation strategies. Most settlement planners have a lot of experience in a wide range of cases working with a lot of different personal injury law firms against a variety of defense firms. So hopefully they're able to add to your arsenal of strategies, and it goes on. As Jeff and Ellen have noted, so these are the things that you want to make sure are in your engagement documents, that you're providing disclosure, you're informing your clients, and you're able to make compliant referrals. What Jack was referring to, of course, is the set of templates that Jack and I and another Medicare specialist have put together as the shortcut for those firms who don't want to create this for themselves. This is kind of the go-to. So you have what you need. So, and it really addresses kind of the three things that we've been talking about. So to narrow your scope, it'll include the templating language for your engagement agreement. More importantly, and this is the more complicated, it includes explanatory disclosures that summarize how key tax, financial, and government benefit concerns may become relevant to the plaintiff's case and the potential impact. It also includes a discussion of how to find the right specialists. Largely, this is about the various types of advice provided and their experience and qualifications, but it also addresses the referral requirements that we just discussed. You can create these yourselves. You can work with specialists. You can buy this as a shortcut. Because they'll help reduce exposure. As Ellen mentioned, Swiss Re offers eligible firms a reduction in malpractice insurance premiums of up to 10%, and actually in return, SPI, Settlement Professionals, offers a 20% discount on the packet for Swiss Re insureds. The other service that Ellen had mentioned is the settlement triage service, which is also part of your malpractice insurance plan. Lawyers insured by Swiss Re can call in to SPI once a month on a case, or even on a hypothetical case, to talk through all of the issues we've been discussing today. Then this is the issue spotter call. You'll learn about the case, identify the issues outside your normal scope, and SPI will recommend next steps. Some you'll want to do yourself, or ask a group you regularly work with to handle it. If you like, you can engage SPI to handle all of them, of course. The service comes as part of the insurance plan. If you don't have a case, I would suggest, though, calling in even with a hypothetical. You'll get a sense of the service, what is really being offered, and also kind of a bit of a sampling of the kinds of strategies that SPI uses to increase the net settlement. So that is kind of bringing us to the end. For both the triage service and the protection packet, you can access information, discount codes, and schedule a triage call on this webpage here. Both are part of the partnership that SPI and Swiss Re have created to offer benefits to insureds. So with that, thank you for taking the time to join us today. We'll be glad to take any questions.
Thank you, Jeremy and Jack. As I said in the beginning, we have seen a number of claims where settlements were entered into, and then a plaintiff or a client found out, gosh, I didn't know that I was responsible for this, or I didn't know, I owe taxes on this, and they can get quite expensive, high exposure, and the one thing as a claims handler that I found, a lot of times there was no documentation as to whose responsibility this was. So these engagement letters that you've put together are very helpful to put out what what the responsibilities are. But one question that I have is, why can't a plaintiff's attorney just tell clients that I'm not a tax lawyer, I'm not giving tax advice? Is that sufficient?
Sure, Jack. Do you want me to take that one?
Yeah, you answer that one since it's on tax.
Sure. Yeah, absolutely. So the key answer is because you are asking the client at engagement, you're asking the client to limit the scope of engagement. And what the ABA rules say is you can't just limit the scope of engagement without getting informed consent. It's very similar to the process of asking for a conflicts waiver. You need to get that informed consent. It needs to be in writing, and it needs to, all of the things that go into informed consent, right? The client needs to understand what the gravity is of that. So, most unsophisticated clients coming in on a personal injury claim, if you tell them, well, hey, I don't give tax advice, and there might be tax issues, you might pay more tax. That doesn't tell them that, in fact, they might end up keeping less than half of what they might otherwise keep. It doesn't tell them that they might actually end up over the next many years, even though they might have medical expenses, they won't be able to deduct them unless they work with a tax professional to help them with that. And there are countless, they're not countless, there are a finite number of issues, but there are many issues. And that's one of the things that the disclosure forms that we prepare on each of these subjects do, is it tells the client, here are the risks. If you're not going to get tax advice from me, if you don't go get tax advice from someone else, here are the potential consequences. And when they sign that form and sign up to be a client, they're agreeing to the limited scope of your engagement. And as Jack said, and I think this is really important, because often I think folks are concerned about saying to a client, I need you to sign that I don't give, to a limited scope. But there is nothing wrong with saying to a client, hey, I'm here to get you as big of a settlement as I can, as big of a recovery as I can. I'm a trial lawyer, but I'm not a tax lawyer, and I'm not going to be giving you tax advice. I'm not going to be giving you tax advice, and that's in the engagement letter. And so when you're signing, that's part of it. And you don't necessarily need to talk through that, but if the question were to come up, I think it is entirely appropriate for a trial lawyer to confidently say, I'm going to do a great job for you. I'm going to get you as large of a recovery as is possible, but I won't be giving you tax advice, and I'd be glad to connect you with someone who can. But that's the reason why it's just not enough to say to the client, or even say it in the engagement letter, to just say, hey, I don't give tax advice. You need more in order to make the narrowing of your scope effective.
Right, and with everything in defending legal malpractice cases, documentation is the key. So I do appreciate the necessity of that. You had mentioned that you do triage calls. What are the typical kinds of things that you end up discussing with attorneys? And I imagine this is a plaintiff's attorney, for the most part, is about to enter into a settlement and calls you and says, can you take a look at this? What are some of the issues and the problems that you see at this point?
Sure. Ellen, let me jump in on that one. The triage call, they're usually 15 to 20 minutes, but they can be far-ranging in terms of the topics. We generally ask an attorney to start off by just giving us the who, what, where, and when of the case, and then we ask a couple of leading questions, and they're namely, who's been paying the medical bills, or who has paid medical bills for the client up to the date of the call, and the next question, of course, will be, or the answer to that will lead us to understand who's going to be paying medical bills in the future and for the rest of their life. And then also, what checks have they been getting for support and income while they've been disabled from the accident or incident, or are they? So those are sort of the two big ones, but there are some others that reveal some interesting situations in these cases. One is that if we'll ask if a complaint has been filed, and if the complaint has alleged punitives. So punitive damages are an issue that we need to address early, and especially at settlement. Many insurance policies that defendants are carrying, specifically exclude paying for punitives. So while trial lawyers use the threat of punitives for leverage, there are specific ways that we need to help trial lawyers with in terms of crafting language in the settlement agreement that makes it clear that the defendants don't think that the chances of proof would have been maybe very high, and that none of the money they're paying is for punitives. And of course, it works to the plaintiff's advantage too, because punitive damages are taxable damages, and they're especially onerous because in most cases, plaintiffs end up paying tax on the portion of punitive damages that are paid to the attorney as attorney fees. It's a double taxation issue. Some of the other issues that we cover are we want to know who the defendant is and who their insurance company is. As Jeremy alluded earlier, or just a little bit ago, about mediation and settlement support, we've seen a lot of these defendants over and over and over, and a lot of them have these really interesting sort of hidden settlement agendas. And so, identifying that casualty insurance company and being able to then pre-warn the trial lawyer as to what they should expect to see leading up to the settlement, during mediation, and even post-settlement, that can affect dramatically the net settlement to the plaintiff. So those are I'd say would be the big issues. Where's the personal injury victim's income been coming from the date of the accident or incident to the date of our call, and of course where it's going to come from in the future, if it has to be replaced. For instance, a great example is if in a triage call, this may start off as a call about a liability case, but when we ask the question about where's the plaintiff's or the claimant's income coming from, what checks are they getting, and the trial attorney says, oh, well, they get money from workers' comp. Well, then that takes us down a tangent of the proper strategy and sequence for settling the third-party case, usually ahead of the comp case, and why. And then there's a special intersection there with regard to Medicare, because comp tries to be extremely proactive and in the Medicare set-aside space. And there's a really great opportunity in third-party liability if you sequence these settlements correctly, where you can end up generating a bigger recovery on the comp side because you've taken care of the Medicare issues in the third-party liability case ahead of time, and then comp doesn't have to deal with that, and potentially there's more money that they can afford to spend on settling that case and those future indemnity benefits. So.
Wow, that's really interesting. I've had claims where the workers' comp lien was not protected, and that causes problems. So, but it sounds like the key to this is going through all these issues before the third-party settlement agreement is signed, because otherwise it's probably too late.
Yes. And as Jeremy said, and as we presented, getting ahead of these issues with the client, and really, I think best practices are at the point that the engagement is created. I mean, most attorneys have a contingent fee engagement letter or a contract, and in practice, it seems like that's the perfect moment to cover these representation issues and get the client's informed consent that if taxes, if financial issues, if Medicare, if liens, if any of those issues come up during the during the settlement of their case, or even into a trial and post verdict, that's outside the scope of the trial lawyer's representation, and they may need other experts involved. Then, when we do a triage call with an attorney, and if they've already gotten past the the disclosures and informed consent, and we start identifying these issues, then it makes it really easy to go back to the client and say, okay, I've had a consultation, and we've discovered some things here that we need to make you aware of, and it looks like we probably will need to get you some additional advice and help. And then, what's really in this day and age, Ellen, it's really, and I think a lot of trial lawyers that are listening in on this will identify with this. It's one of the biggest sort of complaints that I hear from trial lawyers is how long it takes to collect a settlement nowadays. From the date that you've actually got an agreement to settle, it used to be, I mean, this is going back quite a ways, and I'm dating myself, but I can remember a time when we could settle a case in a mediation on Friday. Plaintiffs would go home to think about things over the weekend. Plaintiff attorney would start calling lien holders and have them handled on Monday or Tuesday. Settlement agreement would be available by the end of the next week, and we'd have money and paying a client sometime around the middle to the end of the third week from the date we settled the case. Nowadays, I haven't seen that in a long time because of all of these issues that have to be decided. If the client's on Medicaid, now is that a benefit that they need or want to preserve? And if so, then we've got to set up separate meetings with supplemental needs, special needs, Medicaid preservation trust attorneys to get that part drafted. Many times it takes notice to the state Medicaid office for them to object. They usually get 2 weeks. I mean, all of this starts stringing things out. And then, another famous one that I see pop up over and over is clients on or becomes eligible for Medicare. Maybe not the day they signed up with the trial lawyer, but sometime in the ensuing period while their case is being worked up and they're trying to get to a mediation and they got a court date off in the future. It might be 2, 3, 4 years while all of this is going on, and during that time period they may have applied for and been accepted into Social Security disability, and of course after 24 monthly checks they get their Medicare card, and now bills start going to Medicare, and so you get to the end of the process here, and you're in settlement. And I don't know how many times we've discovered or gotten phone calls from trial attorneys who have said, "Hey, I'm at the mediation," and the defendants have said to me, "Hey, by the way, yeah, we just agreed to settle the case, but until you get us a final demand letter from Medicare, we're not going to hand over any money." And that process of obtaining that final conditional payment demand letter from Medicare is really time and date driven. From the time, if you haven't notified Medicare of your client's case, if you haven't registered it through the portal or otherwise, and you're making a brand new request of Medicare for a conditional payment report on a client, Medicare's got 2 weeks to issue a rights and responsibilities letter, and up to 65 days after that to put the first conditional payment schedule in front of you. All of the money that Medicare thinks they've paid on that claimant's medicals. And usually that process, by the way, is Medicare will generally go from the date of the incident and all the way to the current date of when you've requested the information, and they'll scrape all of the medical treatments out of their file that have been paid by Medicare. Medicare doesn't discriminate against medical bills that might be outside of the injuries and conditions that are the potential subject of the settlement. In other words, general medical treatment that's been billed to Medicare can also end up in that conditional payment ledger. And all of that has to then be audited, and there's a process for lining it out and challenging it and sending it back to Medicare. That's another 30 days. So consequently, you can be 79 to 120 days or more away from getting a final demand letter when you thought you had the case settled and you were going to get your client paid in a matter of weeks. And that seems to be a major frustration, along with all the others that we see and run into.
Right.
It just takes so much more time.
And yeah, and I remember those days too, where I would basically go to mediation with a checkbook and we would get the case settled.
Yes.
But I think what you are highlighting now is just so many more duties that a plaintiff's attorney is taking on, and so many more things to worry about at the end of the day. So it is not just negotiating a settlement at this point.
Right, and in the triage call, when we have identified that a client's current medical bills are being paid by Medicare or as is really common nowadays, a Medicare Advantage or even a supplement policy, now that takes us down a track with the trial lawyer to discuss this particular issue and what the strategy is, especially with Medicare themselves and CMS, in having a conditional payment demand that you can even lock in for 72 hours around the date of your mediation or settlement conference, so that you know what the number is and you've got it, and not be waiting till just after you've settled the case to go make that query and then find out that it's going to be 2, 3, maybe 4 months before you'll get that final demand and can turn it back to the defendants so that you can request a check and get paid on the settlement so you can pay your client.
Right, and I mean, it helps to eliminate surprises too.
Yep,
for sure.
And it's very disappointing to the poor claimants, the clients, because having done this for a while, and I'm sure you practice, you understand this. I mean, a lot of these clients end up at mediation and they are financially ground into dust. It's been 3, 4 years maybe, and they've not been able to work, or they'll never be able to work. Disability benefits have run out. They used up their savings and maybe even dipped into their IRAs and pensions while they were waiting to get approved through Social Security disability. If they weren't on the job at the time, they've got no comp benefits, and so consequently, we get to mediation, and the poor clients, sometimes their house is in foreclosure, that the car's up on blocks in the driveway. They took Uber to get to the mediation, and they're ecstatic when there's some finality and a settlement is achieved, but then it's major disappointment when there's no funds available for 2 or 3 months. It's big disappointment, and it doesn't have to be that way.
Right. There's no other questions right now, so I think this will conclude. I did want to thank you so much for your time and for going through some of these very important issues for litigation attorneys. We will be sending out an email to participants. If you would like, with my contact information, as well as Jeremy and Jack's, if you would like a copy of the slides or want to submit this for CLE, please just email me. It's ellen_McCarthy@swissre.com, and I'll get you that information. So unless Jack or Jeremy, you have anything to add, I think I'll thank everybody, and we will end this session.
No,
Ellen, it's been a pleasure.
Much.
Yep, thank you.
Thanks so much for your time.
Hey, you're welcome.